Hello, good morning, ladies and gentlemen. Welcome to the third session of the course on the administration of constitutional justice before equality right. Today we have the third session where Professor Borowski will talk about the scopes of application of the fundamental right to equality. Thank you very much to the people who are with us via social media and, of course, the people who are attending in person in the auditorium. I remind you that you can ask your questions through the tools of each one of the platforms in our social media, and also the people who are here in the auditorium can send me your questions through the papers, pieces of papers you've received. And without further ado, I'll give you Professor Borowski. Professor, thank you very much.
Thank you very much again for having me and for the kind introduction. The third presentation of the series of presentations on equality rights from a German point of view will today focus on a decision of the German Federal Constitutional Court on a special right to equality, namely Article 2, Paragraph 3, Clause 2 of the German Basic Law. The right not to be discriminated against because of disability. After my presentation, some remaining questions from the two previous presentations shall be addressed, and then questions that will have raised by today's presentation. The world has now, for more than 2 years, been in the grip of the COVID-19 pandemic. This highly infectious respiratory disease affects people differently. One might say it discriminates. The risk of a severe cause of the disease or death rises dramatically with age and certain pre-existing health conditions, particularly a compromised immune system and lung and heart conditions. Vaccination improves the chances of surviving an infection and avoiding a severe cause of the disease, but does not change the unequal effects of the virus. Anyone with a higher basic risk for severe disease and death will, even after vaccination, have a higher risk of a severe cause of the disease and death compared to vaccinated younger people and vaccinated people without pre-existing health conditions. The pandemic has become a very complex issue. Different vaccines were developed which differ in their effectivity. The effects of every vaccination, unfortunately, wane over time. The protection against near transmission and infection, which may well be light infection, wanes far more quickly than that against severe disease and death. This is relevant in the context of the justification of measures against the COVID-19 pandemic, in particular, a legal obligation to get vaccinated, because protection against severe disease and death is protection of the vaccinated individual, while protection against transmission is largely protection of other people than the vaccinated individual. To add to the complexity, the new coronavirus mutated and continues to mutate. The original strain, the Wuhan wild type, was exceeded in infectiousness and pathogenicity by new variants of concern, namely alpha, beta, and delta. Every wave caused by a new variant leaves a certain immunity in the population, which may or may not protect against other variants of concern. With the Omicron variant, a second serotype of the virus has emerged, which boasts of significant immune escape, so that those who were vaccinated against the wild-type alpha-delta family, or those who recovered from infection with one of these variants, still are quite likely to be infected. Whether an infection with Omicron gives rise to immunity against the wild-type alpha-delta. Depends on whether one has been vaccinated with the original vaccine against the wild-type alpha-delta family or recovered from an infection with such variant. If yes, an infection with Omicron boosts the initial protection. If not, an infection with Omicron does not give rise to immunity against previous variants. Fortunately, Omicron in general has proven less deadly and causes fewer cases of severe disease. This is, however, a matter of degree. We are told that the Wuhan Alpha-Delta family will likely come back to Germany in the autumn with a new variant that will probably cause a new wave of infections. Governments around the world have employed certain measures against the transmission of the disease to prevent primarily death and severe cause of infection, with different effectivity and different collateral damage, detrimental effect, for the economy and social life. From the German point of view, a balancing between the right to protection of life and health, according to Article 2, Paragraph 2, Clause 1, Basic Law, with the resulting interference with liberty rights, freedom of religion, freedom to pursue economic activities, and the like, must be undertaken. The legal evaluation of these measures depends on the relevant variant that is currently spreading and the extent of immunity in the respective population to precisely that variant. Legal measures cannot prevent every death or severe illness, but can reduce the likelihood of falling victim to the disease, can reduce avoidable deaths. There are unavoidable deaths and avoidable deaths. The most important aim of the legal measures against COVID-19 generally was to prevent the hospitals and in particular the intensive care units from becoming overwhelmed. If a patient needs an ICU bed with ventilation but does not get one, it is basically certain that this person will die soon for lack of oxygen in the blood. You can only administer morphine to ease the process of dying. If more people need an ICU bed and ventilation, then there are such beds available, then a decision on a chance to live and the certainty of death has to be taken. This is the classic situation of a triage, which is historically known from battlefields. A tragic situation in which not every wounded soldier or non-combatant can receive life-saving treatment. The COVID-19 pandemic has made this situation a real prospect. Not only that COVID-19 patients may compete for ICU beds, but also COVID-19 patients with other life-threatening illnesses, such as heart attacks or strokes. Even though the competition for life-saving treatment is basically a known possibility, there are no legally binding rules for this situation, at least not in Germany. Different criteria are imaginable, such as preferring young people over old, maximizing the years of life according to concrete life expectation, evaluating the quality of life, or a simple first-come, first-serve approach. The approach in Germany is and was to entrust the decision to the doctors, who follow certain guidelines drawn up by medical associations. These guidelines currently provide for the likelihood of surviving the acute COVID-19 illness or other illness as the only permissible criterion for deciding whom to treat, apart from the wish of the patient. If the patient doesn't wish to be treated, of course he is not receiving treatment. This is a complex medical decision for the case at hand. Other criteria, age, pre-existing medical conditions, being vaccinated or non-vaccinated, are not permissible criteria as such. They may only be considered insofar as they actually affect the likelihood of surviving the acute phase of severe disease. There is a debate not only on the very criteria of the prioritization, but also whether the criteria must be recorded in a parliamentary statute. According to German constitutional law, important decisions must be taken with democratic authority. And the decision who gets a chance to survive and who not is definitely an important decision. Fortunately, in Germany, in general, ICU wards have not become overwhelmed yet, so we are told, although there were times at which this was a close call. This remains, however, a realistic possibility because one cannot rule out an aggressive and highly pathogenic variant with significant immune escape in the future, maybe in the autumn. Against this general backdrop of the triage situation in COVID-19 cases, the decision to be discussed here today focuses on disabled persons. The problem is this. Many disabled persons have, owing precisely to their disability, pre-existing health conditions that reduce their likelihood of survival, even if they are treated in an ICU. Disabled persons and NGOs representing the interests of disabled persons voiced the fear that disabled persons might get discriminated in a triage situation. If being disabled is not used as a criterion as such, then there is no direct discrimination. Because the likelihood of surviving the acute phase of the COVID-19 infection is the only substantive criterion, being disabled is not used as such as a criterion. Ergo, no direct discrimination. There might be, however, indirect discrimination. This is the case in which a regulation is neutral on its face, but typically replicates the results of direct discrimination. Since disabled persons much more often suffer from pre-existing health conditions that reduce the likelihood of survival in the case of the severe course of COVID-19 compared to the general population, the question is whether this replicates to a significant extent the consequences that would occur in a case of direct discrimination. In other words, does the prohibition of discrimination of disabled persons in Article 3, Paragraph 3, Clause 2, German Basic Law, is on the handout, the version, does this provision require to treat disabled persons with a pre-existing health condition in the triage situation as if they had no pre-existing health condition? From a moral point of view, one may immediately be inclined to claim precisely this consequence, since disabled persons already have a harder life, and suffering further in the COVID-19 triage would even add to that hardship. From the legal point of view, it should be emphasized that the second clause of Article 3, Paragraph 3 Basic Law reads as follows: no person shall be disfavored because of disability. By contrast, the classic prohibition of discrimination in Clause 1 reads, no person shall be favored or disfavored because of sex, blah, 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 etc. It seems that the wording of the constitutional amendment from 1994, discrimination of disabled persons, explicitly permits and possibly requires that disabled persons are favored over people that are not disabled. If a disabled person with a severe pre-existing health condition is, so to speak, artificially treated as if this person had no pre-existing health condition at all, the disabled person might well be preferred over a not disabled person with, let's say, a moderate pre-existing health condition. The virus does not, however, care about our moral and legal considerations. The likelihood of survival of the disabled person with a severe pre-existing health condition remains significantly lower than the not disabled person with a merely moderate pre-existing health condition. If the former, the disabled, is preferred over the latter in the triage, more people will die compared to the situation in which the criterion of the likelihood of surviving the acute phase of the COVID-19 infection is consequently applied. And the chance of survival of persons that are not disabled is reduced, although this cannot be justified from the point of view of optimizing survival in the acute phase of COVID-19. So, the triage in general raises difficult moral questions, and this applies also to the special problem of indirect discrimination of disabled persons in the triage. The decision of the German Federal Constitutional Court from 16 December 2021, so it's just about 3 months old, is only the third Senate decision, full Senate decision, of the court on legal measures in the COVID-19 pandemic. 9 persons filed a constitutional complaint against the state's omission of measures, effectively protecting them from being discriminated against because of their disability by health providers. Senate decisions of the German Federal Constitutional Court typically have head notes, Leitsätze, which are an official component, official part of the decision. The first head notes reads, and this is also on the handout, Article 3, Paragraph 3, Clause 2, Basic Law provides for the prohibition of direct and indirect discrimination because of disability by the state, and for the duty of the state to effectively protect people against being discriminated against by third parties. Now, this sounds promising for the complainants. The second head note emphasizes that there is, in the circumstances of disabled persons in the COVID-19 triage, a definitive duty of the state to protect them against being disfavored in the allocation of vitally important medical resources. And the third head note points out that the state has empirical and normative discretion with an eye to the decision how to fulfill the obligation to protect, considering, however, that effective protection is granted. The court finds in number 1 of the tenor of the decision that the federal legislator has violated Article 3, Paragraph 3, Clause 2, Basic Law, because the legislator omitted arrangements, Vorkehrungen is a bit vague, arrangements, to the effect that no one is disfavored because of disability in the allocation of vitally important medical resources. So, successful, the complaint. Number 2 proclaims the obligation of the federal legislator to make for such arrangements immediately. In the first part of the judgment, the court gives an introduction into the key aspects of the relevant problem, which I have already explained at the beginning of my presentation. Then the 9 complainants are introduced. Most of them were suffering from significant disabilities. 4 of them suffer from spinal muscular atrophy, 1 from Down syndrome with additional serious birth injury, and 3 from other severe pre-existing health conditions with an eye to the risk to die from COVID-19. Only the 9th complainant with coronary heart disease and diabetes type 2 was considered not disabled. His complaint was consequently ruled inadmissible. The complainants basically claim that being subject to the criterion of the likelihood of surviving the acute phase of the COVID-19 infection in the allocation of vitally important medical resources amounts to a discrimination on grounds of disability. In fact, even though they do not explicitly say that, they claim indirect discrimination. What is more, they claim that the legislator must enact a parliamentary statute for decisions in the triage situation. Guidance by medical associations would not be enough. More than 1/4 of the whole judgment summarizes statements from federal organs, the German states, medical associations, and NGOs. The court typically solicits such statement from relevant actors to understand all facets of the problem as comprehensively and as thoroughly as possible. With an eye to the result, particularly important are the statements of medical associations according to which decisions on certain prioritizations are typically made ad hoc by doctors, owing to significant pressure of time, that these decisions typically contain subjective elements, and that medical personnel often has deficits in the knowledge of disabilities. A constitutional complaint against the omission of the legislator is a specific procedural category, and the complainants have a particular burden of demonstration. A situation in which the triage might become necessary is realistically possible, and it is also realistically possible that the complainants are discriminated because of disability in the allocation of vitally important medical resources, both at the time when the complaint was filed and at the time of the decision of the court. According to the first statement in the grounds, Urteilsgründe, the court sees itself only forced to decide whether, ob, the legislator is under an obligation to make for effective arrangements against discrimination on grounds of disability in a triage. This is somewhat surprising because the decision on whether the state must do something can hardly be separated from the decision what precisely, was, must be done. To be sure, the court grants discretion to the legislator, but discretion may well lead to the conclusion that it might be proportionate for the legislator to do nothing. If this is supposedly to be ruled out, some more legal argument would actually be called for. After a brief characterization of disability, the dimensions of the prohibition of discrimination on grounds of disability are explained, the dimensions of this constitutional right. This commences with the negative right against the state not to be discriminated against, directly or indirectly, on grounds of disability by means of state action. This is obvious because the state is the addressee of all constitutional rights, including special rights to equality, such as the one in question here. Most hospitals are not, however, run by the state. Second, the prohibition of discrimination on grounds of disability also establishes a constitutional entitlement to equal participation, gleichberechtigte Teilhabe, financial subsidies to establish equal opportunities compared to non-disabled people. Money, however, is not at stake in the triage. Third, the prohibition on grounds of disability provides for an objective constitutional value, objektive Wertentscheidung, that is relevant in all branches of the law. In this context, private law is key, for most hospitals are run by private providers. They provide medical resources in general and hospital treatment in particular on the basis of private law, even if heavily regulated by the state. This is to say that decisions on the allocation of medical resources by private hospitals are not state action. The problem here is that the effect of constitutional rights in the horizontal relation between and among private parties, the problem of Drittwirkung. Direct Drittwirkung, according to which private parties are directly committed to constitutional rights, cannot be reconciled with the wording of the relevant provisions of the German Basic Law. Already in the 1950s, the court preferred indirect horizontal effect in the famous Lüth decision. This classic indirect horizontal effect, which is limited to the interpretation of parliamentary statutes in conformity with the Constitution, needs to be developed further into the modern form of indirect Drittwirkung, Drittwirkung mediated through rights against the state. This is particularly obvious in cases in which there is no parliamentary statute to be interpreted in conformity with constitutional rights at hand, in the case at hand, and our case here is precisely such a case. There is no parliamentary statute on the triage in general and on disabled people in the triage in particular. This is to say that there is a constitutional right to protection of disabled people against the state, that the state enacts a parliamentary statute that prohibits other private parties from discriminating against disabled people in the allocation of vitally important medical resources. This is Drittwirkung over the triangle, so to speak, that indirectly gives rise to legal effects between and among private parties, according to which no private party may effectively discriminate against any other party on grounds of disability. In concretizing rights to protection by means of the principle of proportionality in the form of the prohibition of insufficient means, Untermaßverbot in German, free results are possible. All possible means of protection must be evaluated by means of proportionality analysis, and then all proportionate means must be compared. Free results are possible, just as mentioned. First, no means of protection is definitively required. Second, one particular means of protection is definitively required. Third, a single means of protection from a certain class of mutually exclusive means of protection is definitively required. The first result is the norm. The state can decide whether a parliamentary statute is enacted, and if so, which means of protection are employed. Very rarely, only a particular single means, result 2, is constitutionally required. Every other solution, doing nothing or employing the wrong means of protection, violates the Constitution. In between, one finds result 3, according to which there is a class of different means of protection. The legislator is required to employ one means from this class, but is not supposed to do nothing or to employ a means which does not belong to that class. The court refers to the importance of the protection of life, but emphasizes that there's generally wide discretion. Here one would expect that the court considers that triage decisions are a question of life and death, which would strongly call for less wide discretion. This might lead to the result that indirect discrimination must be ruled out by providing for corresponding criteria for triage in a parliamentary statute. The court, however, proceeds in a different direction. Without much further justification, the court explains that the legislator can choose, however, among different means for protection, such as provisions establishing the criteria in the triage, Regelung des materiellen Rechts, or provisions on procedural matters, Regelung des Verfahrensrechts, such as the requirement that the triage decision cannot be taken by one person alone, 4 eyes principle, that there are certain requirements of the documentation of the triage decision, or that the issues are taught in education and continuing education in the relevant professions. Considering that means of protection with rather weak effectivity are supposedly in the class of alternatively required means in the sense of result CC, the third result, the question arises as to why doing nothing shall not be proportionate. There is little, if any, argument from the court on this issue. The court then supports its results by considerations from international law, namely the European Convention on Human Rights, the United Nations Convention on the Rights of Persons with Disabilities, the International Covenant on Civil and Political Rights, and the International Covenant on Economic, Social, and Cultural Rights. These considerations remain rather pale, and the court says that there is not more protection from international law compared to the basic law. Now, surprisingly, the court does not address the issue of indirect discrimination in its reasoning explicitly at all. Instead, the likelihood of surviving the acute COVID-19 illness is just declared to be as such a permissible criterion. What this means for the issue of indirect discrimination is not explained. It mentions also the problem of the triage a couple of pages later, and here the key passage reads, and again the key passage is on the handout, in the case of a pandemic-related triage, the attending physicians have to take a very difficult decision. They have to decide who receives the scarce resources of intensive care and who does not. In this situation, it can be particularly demanding to allocate the necessary medical resources to persons with a disability. This can only be achieved if it is made sure that solely the actual and short-term likelihood of survival is decisive. Close quote. Now, this means that subjecting disabled persons with their typical pre-existing medical conditions that render them particularly vulnerable to COVID-19, to subject them to the criterion of likelihood of surviving the acute illness, does not count as an unconstitutional indirect discrimination. Now, whether this is not indirect discrimination from the outset, or whether this is a prima facie unconstitutional indirect discrimination that is, however, justified by a competing principle of sufficient weight, equal treatments of persons that are not disabled, remains completely the secret of the court. What, then, is the indirect discrimination that is prohibited according to Headnote 1 of the decision? The problem is that disabled persons might be inadvertently disfavored in evaluating their likelihood of short-term survival because the attending physicians follow a schematic approach or follow unjustified stereotypes. What is more, the guidelines of the medical associations in their current form are not entirely clear that the expectancy of life beyond the acute phase of COVID-19 is not supposed to play any role at all. Any court decision can be measured by two different yardsticks. First, is the result correct? Second, is the justification of the result convincing? There seems to be a tendency to focus primarily on the result. Admittedly, there are hardly convincing justifications of decisions with wrong results. The less clear the result, however, the more important becomes the justification. The extensive statements of the federal organs, German states, medical associations and NGOs suggest that positive morality in Germany is divided. Subjecting disabled persons to the criterion of likelihood of short-term survival can be regarded as an unconstitutional indirect discrimination or not. The court chose not to regard it as an unconstitutional indirect discrimination. There can be a reasonable disagreement about this result, which is to say that it is difficult to say with confidence that the court came to the wrong conclusion. The court gives, however, hardly any justification of this result. What is more, even the crucial issue of indirect discrimination is not even openly discussed in the judgment. And the key phrases that implicitly states that subjecting disabled persons to the criterion of the likelihood of short-term survival is not unconstitutional indirect discrimination can only be found in marginal number 123, rather hidden in long considerations. By contrast, the unclear Headnote 1 of the decision permits anyone to read into indirect discrimination what he or she prefers. Immediately after the publication of the judgment, persons and organizations defending the interests of disabled persons issued triumphant press releases. They had not realized that they had lost rather than won the issue, the main issue at stake. Instead, measures with quite limited effect against stereotyping have to be enacted in the form of a parliamentary statute, and the legislator has wide discretion what to do precisely. Such wide discretion that the question arises with why doing nothing supposedly is not an option. To quote the title of a case note written by my esteemed colleague Stefan Huster from Bochum, much ado about nothing. Thank you very much for your kind attention. Thank you.
Muchas gracias.
Thank you very much, Professor Borowski. We have many, many questions for you. And many of them are related, well, or have this comparative spirit of the situation in Germany and Mexico. There's a lot of people who were in last year's conversation in March. So this is the continuation of that conversation with a specifically legal judgment, because at that moment we didn't have that. So this is my proposal for you. Let's have 1 or 2 rounds with questions that were pending from the previous sessions, and they are also linked to what you are explaining, and then we will start with the COVID questions, so to speak. So, from the general pending questions from previous rounds, there's one that it continuously appears. Well, the wording changes, but the question in general is there any substantive difference between the proportionality test and the equality test? Because many people think that the equality test is the proportionality test without the necessity step. And what do you think about these proposals of combining both models? The proportionality test with some levels of scrutiny. The second question is much more general, and is if you consider that the proportionality test should only be used for disputes between public policies and fundamental rights, or is it possible to expand the use of the test to regular conflicts between rights, not only fundamental or constitutional rights? And the third question is, you promised in the first class that you would talk about a case, maybe I remember it well, it was the payment of a lawyer by the state in a litigation. One person was asking the state to pay for the lawyer to have a proper defense. And unlike what happened in other legal systems, whereby litigating was very expensive and people were left out in a much worse situation, and in Germany there was a decision about this. So they are asking you to tell us more, and also tell us more about the proportionality test, how this decision would be studied.
Yeah, thank you very much, actually. I will answer the questions in the order in which they were mentioned to me. Just a brief remark on question 3. I'm a lawyer. Lawyers make never promises. So I kind of announced I would say something, but I say something about it, but of course I will honor my announcement, even if it's not a promise. Okay. Yeah, thank you very much for question number 1. Question number 1 actually goes precisely to the heart of a big problem, how we can compare and to what extent on how we have to distinguish the structure of assessing claims stemming from liberty rights and claims stemming from equality rights. The question, are there substantive differences? Well, I would identify substantive with issues of content. And the first remark is, whatever we do in terms of structure, when we compare liberty and equality, if it's about balancing, in assessing claims stemming from liberty, we balance liberty principles. And if we assess claims stemming from equality rights and balance, we balance equality principles. And the general principle of liberty is a different principle from the general right to equality. And we need to make the comparison only if it comes to equality. So much with an eye to the content. Now, with an eye to the structure, it was mentioned that assessing claims stemming from equality, proportionality is applied without necessity. I agree insofar as external ends. Sorry, precisely the other way around. No necessity insofar as internal ends are concerned. My example was the taxation example in presentation 2. But if there are external ends, this was the protection of the environment. So a distinction is made that the protection is protected more, and the higher protection of the environment that actually realizes environmental protection to a greater degree is realized through what I called an empirical means-to-end relationship. There is an incentive set. So you get a tax rebate when you buy this economically friendly heating system. And then, as a matter of fact, a causal effect of this incentive is that human beings strive for this incentive. They want to get the incentive. So they take the decision to do that. They install the heating, and then the environment is protected. This is an empirical means-to-end relationship. Here, you can actually apply suitability. This is the first prong. Necessity, the second prong. And then balance the cost in terms of equality, because unequal treatment arises. Only those who have this environmental friendly behavior get the benefit. So an equality cost is paid, and we get something on the side of the realization of the protection of the environment. And these two effects then can be balanced with each other. So in that sense, I take the liberty, so to speak, to disagree. I think insofar as proportionality is applied to external ends, then it is suitability, necessity, and proportionality in its narrower sense. And insofar the end in question is what I called an internal end, there is no means to an end relationship in empirical terms here at issue. And here you only can, as the new formula suggests on the handout of the presentation of lecture 2, the new formula suggests that you can compare differences with different treatment. Cost in terms of equality, benefit in terms of an internal end. So the question whether we can combine these two standards of assessment, I would say no, you cannot combine them because they are structurally basically already identical. So you would combine, so to speak, the overarching structure is behind it. You would compare two instances of the very same structure into one other, which doesn't work. And with liberty, you do not compare anything with liberty. And with equality, you have to compare something. You can't combine that. That doesn't work. You can apply, of course, in one case, if you have, maybe this is the background of the question, just occurs to me. Of course, you can have in one case, if we talk about equal interference, you can in one and the same case assess whether actually from the point of view of liberty rights, state action is unconstitutional. And if, irrespective of the answer, after having done this assessment, you can make a second assessment whether from the equality perspective, the state action is unconstitutional. In this sense, you combine them in the sense that you do in a sequence, sequentially, the liberty assessment, and once this has been done, the equality assessment. And this is the normal order of assessing claims stemming from constitutional rights in Germany anyway. And you may remember in the first lecture that I said that it's not entirely clear whether the general right to equality gives rise to this formal protection effect, whether there needs to be a parliamentary statute that actually justifies formally unequal treatment. How can it be that this has not been discussed in Germany, where we discuss everything over and over again? How can this be the case? Well, the issue is this. If you assess, so to speak, whether constitutional rights have been violated, you begin with liberty. And if there is no parliamentary statute that legitimizes an interference with liberty from the formal point of view, independently of whether this is proportionate or not, already you have a violation of the state action in terms of liberty. So you have, before you come to the second step of assessing equality, you have already determined in the liberty evaluation whether there's actually this formal problem. So it doesn't really matter, because if there is a formal problem, already the liberty, so to speak, assessment comes to the conclusion that it's unconstitutional, then you don't ask the question of equality anymore. But if you raise the question of equality, you have determined that there is actually parliamentary statute that is, so to speak, constitutional. So it doesn't really change the difference whether you assess this additional information for liberty rights. Okay. Question 2. Proportionality. Can proportionality only be applied to a competition of rights with what Ronald Dworkin called in his early writings on the principles theory policies, or as we would say in German constitutional law, collective goods, kollektive Güter. An example for such a collective good, or you may say policy, is the principle of the protection of the environment, which is in Germany required aim of the state. So it's a constitutional aim. The state does not have discretion whether to strive, so to speak, for constitutional for protection of the environment, but there is a constitutional obligation of doing so. So there is no liberty whether to realize this to a certain extent or not. The state is under an obligation. Structurally, the kind of famous problem that Dworkin had with policies, that Dworkin considered rights as trumps, and this includes, or this means, so to speak, necessarily, that policies are not trumps. However, Dworkin, and this is often forgotten, Dworkin also says in a later passage in Taking Rights Seriously, he says that rights and policies can also be seen from a structural point of view as principles in the generic sense. And the modern reconstruction of German constitutional law does not actually know of a structural category of policies, so to speak, that is, as a structural category, disadvantaged in proportionality assessment. Whether there's a principle or a right just becomes a matter of abstract weight. So we basically treat what you would call policies and constitutional rights structurally just the same. It all becomes a matter of attributing relative weight to the principles in questions. And of course, rights can be balanced with rights. This is, I think, even the more clear case. And here one aspect came into play, I think, is the aspect of the hierarchy. Can we balance constitutional rights with, let's say, rights in international human rights law? Or can we balance rights with constitutional rights with rights in parliamentary legislation inside the state? And here the clear answer is balancing. Balancing means establishing conditional priority. And balancing, establishing conditional priority means that there is no unconditional priority. So you can only, if you look at the hierarchical structure of the legal system and take the levels of the hierarchy in the hierarchy of derogation, superiority, then you can always only balance rights or even collective goods at the very same level in the hierarchy of derogation. Balancing across levels of derogation is not possible. And this is quite important, for example, if you think of Germany, who generally allows transformation of international treaties and also international human rights treaties into the municipal legal system of Germany only at the level of parliamentary statute. So you can never balance a German constitutional right at the level of a constitution with a European Convention right from the European Convention on Human Rights in the German legal system because the latter convention rights always have a lower level. So the operation that is then done, because you can't balance, is that you say the interpretation of the higher level of rights, national constitutional rights, is actually, so to speak, informed by the level of international human rights law and is in some sense interpreted friendly, so to speak, with an eye to what happens at the level of public international law, because if Germany departs from a result that is arrived at the European Court of Human Rights in Strasbourg, of course, in the external perspective, if it comes to international law proper, if Germany violates the European Convention according to the view of the Strasbourg Court, then Germany will still, in the external perspective, violate international law, even though internally the rights have a lower standing. I know that the situation is different in Mexico with an eye to certain human rights treatises, which gives rise to exciting problems, I think, and you will in the years to come read more about that. Okay. Yeah, I think I should stop here with the second question. The third question, because time is already running. The third question, this is not, my promise that was an announcement. The thing, it's not an individual, so to speak, seminal dramatic case. It is more a long string of cases decided by the German Federal Constitutional Court. And this is in some sense a social right. We had in this decision here at stake rights to protection. These are liberal positive rights. But there are also positive rights to economic redistribution. And Germany, strikingly, in Germany's constitution, has not a single written social right. Does this mean that Germans are asocial people? Are they all hard-nosed libertarians? Not at all. Not at all. Germany has a very pronounced system of redistribution of wealth by means of parliamentary statutes. In Europe, probably the Scandinavians have the most developed social state with taxes that would be unbelievable for US Americans, for example. I think taxes up to 70% or something like that from income. So it's really enormous taxation, but you get very much from the social system. Germany doesn't go that far, but Germany certainly is in Europe, so to speak, on the more pronounced social side. So how can it happen that there are no constitutional rights as social rights in the German basic law? The problem is quite simple. the Weimar Constitution of 1919. It was the last constitution before the National Socialist system, which doesn't really have a constitution. It was just a dictatorship, the Nazi period. The Weimar Constitution beforehand had a relatively modern catalogue of constitutional rights. And I think the Weimar Constitution, with a great many provisions on social rights, social constitutional rights, was far more similar to modern constitutions nowadays, and particularly to constitutions in Latin America. Now, when the Parliamentary Council, that was after the Nazi period, now, so to speak, Germany had to restart and continue to develop into a liberal democracy. Now, people were thinking, what shall we do now? The problem was that the structure of social rights, how do we actually assess claims stemming from provisions granting social rights? How can we do that? Does proportionality play a role? How do we avoid promising too much and then honoring too little? How can we actually make this legally, so to speak, workable? Not just the solemn promise and then nothing happens. This is, so to speak, not something that Germans wanted. And the very binding nature of constitutional rights in general, liberty rights, equality rights, was actually harmed in the views of the Germans in the middle of the 20th century. And they said, well, this problem with these social rights, what to do with them, how to interpret them, this has bedeviled the whole category of constitutional rights. And now they wanted to make a new start, and it was the firm wish of the German Constituent Assembly, the Parliamentary Council, to take liberty and equality very seriously. And so they reduced, so to speak, their efforts of making this legally workable. They reduced this to liberty rights and equality rights. But it was explicitly said that this does not mean that there shouldn't be a social dimension. It's just they thought they have no idea how to do this properly. And to be fair, I don't know much about the Mexican Constitution and the social rights in the Mexican Constitution, certainly. But the problem is still in Germany and Europe, if we talk about the Charter of Fundamental Rights of the European Union, the problem is, in my view, still unsolved. How to, so to speak, legally workable, properly, draw up provisions on social rights, and then have a good system of assessing claims stemming from these rights. And so this is why the German court, now coming back to the precise impetus of question 3, the court developed carefully certain lines of judge-made social rights. And the right to legal aid, that means if you have to defend yourself, if some important aspect needs to be defended by legal proceedings, then the idea of this social right is that you shall not lose the court case or are, so to speak, are stopped from going to court in the first place because you cannot afford the legal fees for the court and for a trained lawyer. And so the court developed this in a line of cases. It wasn't, so to speak, not a dramatic, widely discussed issue. It just piece by piece, so to speak, by developing one case after the other, they decided that, and this is now actually a particular branch, so to speak, of administrative law, that there are certain rules, then this is administered. If you go to a lawyer, say, do we have money? So no. Then you say, okay, but here's the case, and there's some prospect of success. Obviously, the state will not pay for some kind of frivolous claims or trivial things, but if there is some merit, factual merit and legal merit in this, then actually it will be guaranteed that if you lose, the state has to pay. well, if you win, your opponent in court actually have to pay the fees anyway. So this is not a problem. In this sense, this is not a dramatic risk for the state. Okay, yeah. Next round of questions.
Vamos con la...
Okay, let's go with the second round of pending questions from the two previous sessions. The first question is a general question that keeps on coming up in the activities of the center, and is what's the relationship between the proportionality test as constitutional adjudication methodology and the proportionality principle, like in criminal law? If the proportionality test is a way to deal with proportionality issues in different areas of law, like in criminal law, or if it's possible to differentiate them or divide them, and think about the applications of the proportionality principle that are not done through the proportionality test. The second question is, you said, I don't know if it was the first or second session, that Alexi talks about two equality modalities, a factual and a legal one. And there's something called the paradox of equality. So the question, or they are asking you if you could elaborate on the difference, according to Alexi, between factual and legal equality, or what's the paradox? And finally, you mentioned some objections to the Vicki Jackson's thesis about the relationship between equality and the proportionality test. So they are asking you if you could mention your main objections against Jackson's thesis, and if you could elaborate further on the idea of cognizable constitutionally. If it's an epistemological problem, or this is not something epistemological, or normative, or other sort. Those are the three questions.
Relation proportionality tests in constitutional adjudication and in criminal law, probably we could also add some other branches of law, such as admin law, police law, so to speak. Criminal law is the repressive side, and admin law is the, so to speak, protective side. Yes. I think basically the structure of assessing proportionality is the same everywhere. Now that specifically criminal law was mentioned, just so to speak a footnote, when we talk about equality and proportionality, the proportionality, the proportion between the severity of the crime and the legal sanction in criminal law would be something that could be considered to be an internal end in the sense of the second lecture. So this was something I already talked about. Apart from that, I think proportionality is the same in every branch of law. And this, at least the structure is the same. And in different branches of law, of course, there are different principles that are primarily important. So in that sense, there are substantive differences. But the structure, I think, is the very same. And this also has to do with the fact that there is the requirement of interpreting law below the Constitution, parliamentary statutes and statutory instruments, always in conformity with the Constitution. So in some sense, if you apply a parliamentary statute, you cannot simply say, well, this is a kind of different level in the hierarchy of the legal system, and then the proportionality test is something different or so, because every interpretation of a parliamentary statute has to conform to constitutional requirements. And it may well be that you have to balance, for example, if you think about a kind of certain parliamentary statute in a statute, in an act that is devoted to the protection of the environment. And now actually the administration then in applying this environmental statute then interferes with the liberty of a citizen and says, well, but we can do this. This is here kind of empowerment in this environmental statute. But of course, in the background, there is the competition between the constitutional right to liberty and the constitutional value, collective good, of environmental protection. So in applying the statute in and of itself, you always have to do the constitutional balancing to find out whether what would be the result of your applying the law of the environmental statute is actually constitutional. So in that sense, I think it's structurally the same. The legal equality and factual equality is, of course, a translation from Robert Alexie's German original treatise, but the connotations in German are not much different from the ones in English, and possibly, this is not for me to judge, in Spanish. This is basically the distinction. This distinction was in two presentations. It was actually in the first and in the second. In the second, it's the Alexian distinction. In the first, I, so to speak, mirrored this into the general doctrine of the general right to equality. Legal equality simply means equal treatment. This is sometimes also referred to as formal equality. Now, formal has this unfortunate negative connotation. If you say someone is formal, you say, well, this is not really happy. He doesn't really respect the content of the things. He doesn't really see the whole picture. It's a formal thing to do that. Although in this sense here, formal is, so to speak, at least for Robert Alexie, and I would follow him on this, formal is positive. Because the first and most important dimension of the general right to equality is equal treatment. Because human beings are different and live in different circumstances, treating people equally does not reduce factual inequalities. And so if you want equal results, you typically have to treat people differently. To use a textbook example. Now assume that I do not have a talent of playing the violin. And assume that there's someone else who is very talented and gifted in playing the violin. I'm not. Now, we need lessons to improve. The talented person and me. I do not play the violin. It may be that I have a talent that I haven't seen yet, although I would be too old, of course. But let's assume I'm not talented. Now assume that me, no talent, and the person with talent are treated equally. We get 2 hours of violin training by a violin music teacher. What will happen? After a couple of months, you will find that the person with talent beautifully plays the violin. But if I begin to play, everyone runs away. And there's no coin in the hat. No money for me. So obviously, by treating us equally, the talented and the not talented person, we will end up with completely different skills. Good skills, no skills. So what do you need to do if you want me, the not talented person, to play violin as well as the talented person? Now the talented person now gets reduced teaching, just 1 hour, and I need 3 hours, if not more. If we do this for months or years, if ever we come to the identical level of playing the violin, it is perfectly clear I need far more support to achieve the same thing as the gifted person. And the lesson from this is, for whatever reason, whether it's talent or kind of unfortunate situation in which one it is, it's by no means any insult intended. Because of differences there are in the world, if you want to achieve equal results for persons, owing to differences in the world, in persons and situations in which the persons are in, you have to treat people differently to achieve equal results. And this, in some sense, is what Robert Alexi means when he talks about the equality paradox, that very often, when we talk about equality in a kind of comprehensive fashion, if we stare not only at equal treatment in the formal sense, but if you also want to include the dimension of equal results, whether we include it in the general right to equality, that is Alexi's suggestions, and even if we do not have it there, it would be in the principle of the social state, because the social state argues on behalf of redistribution and, at least to some extent, on behalf of equal results. So this tension is there whatever we do. The tension is there. And this is what is meant by this distinction of factual equality, equal treatment. Sorry, legal equality, equal treatment. Factual equality, equal results. This typically competes, so that this is the paradox of equality. Yeah. Vicki Jackson. I'm actually very happy with two things that are the main impetus of her paper. I'm very happy that she applies proportionality to equality, first thing. And second, I'm perfectly happy, from a German point of view, that she argues on behalf, well, at least in the direction of a sliding scale. Why? Because if you have this kind of strict separation between the rational basis test, very lenient, and the strict scrutiny, the compelling state interest test, very demanding, very difficult, then actually most of the work is not done by actually applying the standard. Most work is done in deciding which standard to apply. Not the application of the standard itself, but which is to be applied. Because we know that if you say that only the rational basis test applies, then government has won. It's, well, not strictly in theory, but it's very rare that then there is unconstitutionally found. If the compelling state interest test is chosen, then basically the claimant, or constitutional complaint in the German perspective, has won. So hardly possible that the state actually wins that case. So this is decisive, and then everything, so to speak, the whole justification, in some sense, shifts before the standards. It is not done in the standards, and I think it is right to have the justification in a sliding scale in the standards, because the world is not, as I said recently elsewhere, in a completely different context. The world is not black and white, but there is gray. Light gray, middle gray, dark gray, mouse gray, stone gray, concrete gray, all different shades of gray. And if you have a sliding scale, you can vary the intensity of review without a scale. So in that sense, so to speak, I would say I agree to 70 up to 80% in the impetus and thrust of a paper. But it is often so that the more similar things are, the more important differences become, in some sense. And my point, what was my objection to what he suggested? The objection was was with an eye to a different issue, and that is how do we actually structure assessing a claim stemming from an equality right. And here the structural issue is the question of the scope and the question of the justification. In liberty rights, we usually determine the scope of the constitutional right by interpreting the words in the provision that grants the right. For example, if we talk about freedom of religion, to establish an interference with religion, we must have determined that a certain behavior of a person counts as religion in the legal sense. So we need a definition of religion. And this can be understood narrowly or rather widely. We can be more generous on that front, and typically we can, because if there are legitimate counter reasons against a certain claim from a right, then we have a justification stage where we can consider this counter reason and then actually usually come to balancing. Now the problem, so this is subsumption, we determine the scope, and positive answer, then we move on, interference, and then we move on to the justification. Now the problem with the general right to equality is, the wording is, you have it on the, I think on basically every handout I gave you in this three sections series, Article 3, Paragraph 1, it just says equality. And equality hardly rules anything out. And now Vicki Jackson's reaction, and she isn't alone, is to say, oh, this is too wide. This can't be a constitutionally cognizable claim to equality. And she then tries to find something narrower. And then to find something narrower that determines the scope, and then, if there is a prima facie violation or interference with this more concretization of equality, then move on to the justification stage. And this is a reaction many people have. You find this also in the German case law, when the German Constitutional Court asks whether something has to be substantially the same, not just the same. So it sounds a bit narrower. The only problem here is, and this is, I think, important to understand and recognize, if you look for something more concrete that determines the scope of the general right to equality, the only operation you have for arriving at this more concretized layer of equality is already balancing equality principles with competing principles. So you kind of divide balancing in the sense that you make a kind of more general balancing to determine the scope, and then balancing the case to the, so to speak, complete end. You consider all circumstances of the case at hand, and then you call this justification. My only point, and this point is then has consequences for how to deal with this issue what's actually a kind of prima facie constitutionally cognizable claim to equality. If you try to create something like that, it is the very same structure of justification. It's balancing equality with competing principles. And in that sense, I wouldn't recommend to do, so to speak, the very same thing in two steps that might be difficult to distinguish, where the first step ends and where the second step begins, and then doing, so to speak, the very same operation again for a second time. This doesn't simply strike me as good design, so to speak, for assessing a claim stemming from a right. And at the end of the day, if we do not think that the general right to equality has a formal protection effect, then even the problems that may result in the context of liberty rights from this formal protection effect with a generous consideration of the scope, there are some problems on the liberty side. We don't even have these problems here on the equality side if there is no formal protection effect, which I think would be the way to go for. And so everything you have to do is just with the experience and the intuition of every lawyer, who always, if a lawyer solves a case, the lawyer always has to think, so to speak, of many different legal provisions, many possible claims from various provisions, and we intuitively and immediately, because we know the field, know which provisions we have to seriously and carefully interpret, and which other provisions we can just rule out by just thinking, so to speak, for half a second. No, it's not the case of that. So, and in the same sense, you can, so to speak, very clearly, intuitively carve out what are the constitutionally suspicious, so to speak, difficult to justify differential treatments. And in that sense, I think the question for the scope and the search for what Vicki Jackson calls the constitutionally cognizable claim for equality is, I think, in some sense a distraction. And but as I said, to 70 to 80%, I agree with the general thrust of the paper, and in this sense, I'm, so to speak, happy. Whether this is a kind of epistemologic or ontological problem is a deep question, and I want to leave some. There may be questions related to the triage, so maybe we proceed to that and don't get me started on this one here. Thank you for this second round of questions.
A ver, como para esta segunda ronda de preguntas.
For this second round of questions about today's presentation, we have general questions and specific questions about the triage, COVID, disability, and proportionality. I'm going to pose two general questions and one that has to do with the decision of the Constitutional Court. The first question is if you know of any study about the effects of COVID differentiated by socioeconomic status. Is there any evidence that people whose socioeconomic status is more precarious suffered the impacts of the pandemic more clearly and more deeply? And if you think that one of the effects of this pandemic was the worsening of inequalities, or is it too early to reach this conclusion? And related to this, at some point you said that we had this problem, the problem of prioritization was not about resources or allocating money to one or other program, but if the socioeconomic status is a conditioning factor, and if the scarce resources are one of the reasons why we can give universal care, in what sense this is an issue of the distribution of resources and economic inequality. The second question is, could you talk about how the legal concept of disability is formed in Germany? Is this something that was developed by national doctrine, or if for the construction of the legal binding concept of disability you take into account international human rights treaties, and specifically those that deal with the rights of disabled people? And question number three is that you talked about in the beginning of your presentation of a clash in the cases of the right to life and the right to liberty. And you told us there's a sort of priority of liberty with respect to other rights. So they are asking if you could elaborate on the specific characteristics of this priority of liberty, if it's an absolute priority compared to other rights, if it's categorically more important. And I'm going to combine two questions. And regarding demonstrations, I think in Germany, people who are against the use of masks, people against vaccination, anti-vaxxers, this priority of liberty is the basis of this type of social demonstrations.
Okay, thank you. The social impacts of COVID. There definitely, the COVID-19 pandemic, I'm speaking for Germany, has worsened inequalities. There can't be any doubt about that. It was when people realized how the the infection rates were evolving, it was clear that certain social groups typically had higher infection rates. And this was even combined in, particularly in the UK, there's more evidence from the UK from that than from Germany, that not only different social groups, but also different ethnic groups had different infection rates, and also different rates in some sense of the severity of infection. And now the question, of course, is how to interpret this. If it comes to ethnic groups, you cannot rule out genetic differences because the immune system, there's a very complex interplay between certain virus variants, or the virus in general, and the immune system, which is characterized by genetic differences, and the immune systems of different persons can vary significantly in terms of genetic determination. Actually, there's a natural inclination, I was told by a doctor, there's a natural inclination of human beings, if you choose a partner, automatically to choose a partner who has a different genetic, so to speak, conditioning of his or her immune system compared to yours. So there's a kind of anthropologic inclination to go, so to speak, for partners with different immune systems to improve survival prospects of potential children. Well, you may not think that far in the discotheque, but the biology does in some sense. Okay, but I got sidetracked. the big question with an eye to the ethnic groups was, is this down to speak genetic differences, which are natural differences, or is this down to social circumstances? More crowded housing, less access to information. The COVID-19 pandemic, as I said, is a very complex thing. So to avoid an infection, you have to understand what the virus does in some sense. And if information is not actually accessible that easy for certain groups, housing is crowded. We know social distancing is very difficult if you have a small flat and live with a big family in a small flat, and the children attending different classes at school, so social contacts are mathematically exploding without social distancing. This was one part. In terms of education, in Germany there was a very heated debate on the closure of schools in the first wave of the infection. So schools were closed for quite some time. We didn't have any vaccines. We didn't have any medication to treat COVID-19. So basically the virus did its work and there was only support at that point in time. And schools got closed. And obviously then the education of pupils had to be done at home. And now it is a difference, of course, in terms of social circumstances. If this is a small flat, and if mother is cooking, father is watching television, football games, siblings are running around playing. And now, as a school child, you have to sit at the kitchen chair with some cheap old computer doing some kind of basic things, compared to a wealthy family in which a child has his or her own room, well equipped with a computer, internet is working properly, the computer is a new expensive model, does all the fancy things, and then we obviously saw that the differences in terms of results from this homeschooling were significantly different with an eye to the social conditions in which that happened. And then, sorry, in this context, of course, you highlighted that I mentioned that the triage is not about money, which was a kind of categoric statement. And I looked at it from a German point of view, first caveat. Second caveat, I only looked at the triage situation when the situation in the triage has to be taken. And of course, money plays a role in the whole thing in general. The first thing is, when it comes to money, how many ICU beds do you have? Germany actually, even inside Europe, had and continues to has a much higher number of ICU beds compared to other European neighbors. So we are spending quite some money, generally, on ICU capacity. The problem is, we have learned that logarithmic growth in the pandemic, then basically having twice the number of ICU beds in a pandemic, if the doubling time in a logarithmic growth, exponential growth in the pandemic is 3 days, so you have 3 days more than your neighbor, and nothing more. So exponential growth is absolutely horrible. But of course, with the triage, one thing is crucial. There are some problems, and the best advice you get with an eye to these problems is don't get into the situation. Because once you are in the situation, there isn't a good way out. So avoid as much as you can to get in the situation. And there was quite something done, and of course this also means spending money, so ICU capacity, not to get there. With an eye to money, I should also mention that Germany has universal health care. Not quite the system of the United Kingdom, where this is basically open to everyone and then paid by the taxpayer, but a system that relies on insurance but there's much emphasis on having everyone insured in the state health system, and the state healthcare system is, compared by international standards, a very, 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 very decent health system. There's also a private system, which in some sense is better, but if it comes, more pricey of course, but if it comes to this kind of urgent care, ICU, accident and emergency, and so on, you wouldn't see a difference. So equal access to healthcare in Germany is achieved, I would argue. So not to be compared to something like the United States or so. Legal concept of disability, how was it formed? I have to admit I'm not an expert in this field of social law at the constitutional level, international level, or even at the national level. I have an expert who is, have a colleague who is an expert, or I have an expert who is a colleague. It doesn't really matter. In Heidelberg, he deals with these things. Of course, in 1994, when this special equality right, non-discrimination on grounds of disability, was introduced into the Constitution, obviously there had to be a definition of this constitutional terms of this right. And there are, long before that, there was statutory law in which disability was regulated. And of course, this is integrated into all branches of law. It can be quite important. As a student, you can get some kind of adjustments in terms of conditions of being examined. If you are disabled, there are some provisions in employment law. So in employment, disabled people are not to be subjected to discrimination, and of course, to achieve all these, to apply all these norms, you need a proper definition of disability, and it's a kind of significant long-term impairment. In this case here, interestingly, coronary artery disease, heart disease, and diabetes type 1 were not considered to be, I think, sufficient in terms of long-term and severity to be considered disabled. And if you read the case more carefully, it has not been translated into English, so you, and of course not into Spanish. But if you read the case more carefully, you will see that these complainants with spinal muscular atrophy, or the person with the Down syndrome and birth injury, they basically had to be taken care of around the clock, 24/7. So this was a very hard, severe impairment of their everyday life. And this 9th complainant just fell short of that. Yeah, in the COVID-19 pandemic, a priority of liberty. I think the approach in Germany taken was somewhat different compared to at least what I anecdotally know from the situation here in Mexico. Germans like to follow the law in some sense. In terms of fairness, in social effectiveness, it was generally thought in Germany that you need to have legal rules, legal measures against the pandemic. The less regulated approach would be to say, well, no legal measures. Everyone decides on his or her own how much to protect oneself. The downside is, for example, not everyone just lives in a situation in which he or she can just freely decide whether to engage in social contacts. For example, if you work in the outskirts of a big city, such as Mexico City, and you have to use a bus or the subway or metro or whatever you call it here in the city, well, it's difficult to go by bus in the morning at rush hour time to a workplace for 90 minutes or so, bus ride, and avoid social contacts. You can't. You're sitting in the bus. Everyone is breathing. Now, and everyone else may not wear a mask. I've seen here, and I have to say I'm impressed how disciplined Mexicans are in wearing masks, actually disinfecting hands and so on. I'm honestly impressed. So just reason may replace the force of law. And of course, the problem is legal measures, the enforcement of legal measures was a tricky issue at time. Those people you see in with demonstrations against masks, typically then without social distancing and without masks, to make their point, so to speak, clear, this is a minority. It is a loud minority. It is not necessarily, but also a right-wing group of people who place much emphasis on liberty, kind of libertarians, you could say. Their argument is basically, well, we should do just shielding. We should shield vulnerable people. But this doesn't work. This doesn't work. This was experience. Mistakes were made. I think shielding could have been better during the first first three waves. Shielding could have been better. There were outbreaks in nursing homes and homes for old retired people, and many of them died. But shielding is a very tricky issue, because even if these people stay in their own room in the nursing home, well, what is about actually visits from family? What do you ask of these people if they have to shield? They cannot actually have family members visiting. They have only nurses with kind of plastic, covered all in plastic, no human being, you see. So it's a kind of being imprisoned if you ask vulnerable and people with pre-existing conditions to shield. And it's, in some sense, it's the egoism of young people and people without pre-existing conditions who do not want to kind of stop partying, in some sense. And it was, but it was, by and large, I would say, a minority. And of course, liberty is not an absolute right in this sense. Let me just point out that the German Federal Constitutional Court always has emphasized, in the context of balancing liberty, that constitutional rights are, on one hand, rights of the individual. So in some sense, individualism is at stake. But on the other hand, they have always emphasized that an individual is always a member of society and has to respect legitimate needs of other members of society, or of the society or state in a whole. So it has always, so to speak, mentioned a kind of collectivistic element, if you want so, together with individualism. And so there is no legitimate argument for these kind of exaggerations of liberty, absolutism, or the like. Thank you. I don't know whether I covered all aspects, probably, but I did the best I could.
Tenemos muchas preguntas más.
We have many more questions, but we are running out of time. One round more, the last round, and then we can go. Perfect. Do you know of any case in the Constitutional Court or any discussion about the decision criterion between disabled people when you have to decide to whom you give treatment or an ICU bed, if you have to decide between disabled people, and if you take into account whether this is, well, the disabled person is a child or a woman, if you take into account intersectionality in this kind of difficult decisions. People also want to know about the triage decisions in disabled people in non-COVID contexts. That is, if that was the starting point for the Constitutional Court to make a decision, because this was related to the COVID pandemic. And number 3, they are asking if you think that these triage decisions, like the use of utilitarian tools to define who has a certain right, who has the right to healthcare or who has the right to life, taking into account which decision maximizes the interests or the usefulness or the possibility of survival, or the analysis in this type of cases is more sophisticated than mere utilitarianism.
Yeah. There has been, to my knowledge, no concrete case in the sense that a disabled person was disfavored or favored, and that then legal proceedings were instituted. You may say that in some sense this is an abstract case, because we had no concrete case from which this thing arose. And in some sense, there is a parallel, if you allow me to mention that thing. I don't know if you ever heard about the German air traffic security case, which was about the legal power of police to shoot down an aircraft in a 9/11 situation. This never happened in Germany. It happened in the United States on 9/11. But Germans thought that if such a situation happens, because of the requirement that the parliamentary statute must empower police to do that, just so to speak, for the possibility that this case happens, this statute was made. It was also, in some sense, an abstract case. Although here, with the disabled in the triage, as far as we know, no such case happened. But how can we be sure that no such case had happened? Because it may have been that a kind of priority decision was taken in a hospital at the kind of peak of one of the COVID waves, and we simply don't know. It may not have been completely documented. The decision may have been taken by one person alone. And I think this is part of the impetus of these disabled complainants, because they kind of fear that these decisions might be taken without people realizing, without becoming public. There was also a debate in Germany, because when the hospitals were quite full, there were instances in which very old people, very frail people, living in homes, not in the hospital, living in homes, that then severely became ill owing from COVID, that actually the decision was made not to bring them even to the hospital. And this situation was characterized as the triage before the triage. So the problem is the triage at the hospital doesn't even happen, because you, so to speak, don't even care of bringing those who might have actually had less chance of being treated anyway, not even, so to speak, bringing them to the hospital, because then in hospital they would probably have died in the situation with under morphine, not in the care home they know, in the kind of their known environment, but in a kind of horrible technological, functional hospital. So we can't really be sure whether there were no cases. As I said, it was a bit between the lines in my presentation where I said, as far as I know, as far as we know, as far as this is admitted in Germany. And there are now other intersectional discriminations are mentioned, other criteria as you find them in the German provision, Article 3, Paragraph 3, Clause 1, the traditional prohibition of discrimination. Well, the answer is quite clear if you take the German approach, that only the short-term survival likelihood, how likely is a person to survive the acute phase in the ICU ward. This is the only criterion. And if disability, who is even, if you look at the text of the German provisions, who is even a stronger prohibition of discrimination compared to the other prohibition of discriminations, then it is, so to speak, is even more obvious that the other criteria, prohibited grounds of discrimination, do not play a role. So it's just, so to speak, the likelihood of survival. In the case of children, as far as we know, apart from this inflammation syndrome, which is very rare, children typically do not, unlike influenza, fortunately with COVID, children are not, do not get ill very severely, so that in that sense, children have a very high prospect of surviving the acute phase of COVID, which is very rare, if they actually become very ill. This would be different in terms of influenza, unfortunately. So no, this doesn't play a role. Triage decisions in a non-COVID context. Battlefield. Ukraine. No, is what might happen there. In the kind of normal European course of things, we usually achieve to avoid triage. It may happen if there is a kind of dramatic accident. There was a famous train crash 2 or 3 decades ago when basically a complete high-speed train was in some sense smashed, in part destroyed, because there was a bridge and it kind of crashed into the bridge. And then you will have a situation in which local hospitals are overwhelmed. But Germany is densely populated. It is far smaller than Mexico, for example. And then it's relatively easy. There are many hospitals with many ICU wards, so then you just distribute. Distributing is a problem because if people are very severely injured, then the transport may actually be too much for them in some sense. But generally, I think we do this just by distributing the burden, share this, and the triage situation is, from a German point of view, basically a battlefield thing from World War II and World War I. It is just now, if you have so many COVID-19 patients competing for ICU wards, then you have the additional problem with the COVID-19 peak that the ICU wards are also blocked with COVID-19 patients for those with heart attacks and strokes. And also, this is something that also hasn't received much attention, or not the attention it should. There are some surgeries, operations, you cannot do if you do not have a free ICU bed, because there may be complications. The person may need an ICU bed for a couple of days before recovering in a kind of general ward at the hospital. And this means that that more complicated cancer surgeries were actually not undertaken. And in some sense, the price that COVID-19 imposes on us is not only death from COVID-19, long COVID, but it's also that the whole health system is actually burdened to an extent that the kind of normal functions are not performed to the standard that they should. And there is the unfortunate prophecy that we will see cancer deaths all over the world rising significantly in the next years to come, because the early operations that would have saved people couldn't be done in many cases because hospitals were so blocked. Utilitarian tools. Well, simple utilitarian tools. I think the German criterion, the simple criterion, so to speak, chance of survival in the concrete case, is already chosen because of skepticism with an eye to merely utilitarian tools. Because you could, of course, begin to ask for remaining years of life expectancy. You can have a person that might be 80 years old and a much younger person with pre-existing health conditions. And it's perfectly clear they have the same likelihood of surviving the acute COVID phase. Typically, olders have lower, but it can be because of pre-existing illnesses that this is actually, in this case, the same. It is perfectly clear that someone who is 80 years old will probably have, even considering no COVID and considering no pre-existing health conditions, probably has kind of 5 to 7 years left, statistically. Now, someone who is 30 with the same COVID short-term survival prospect, if this person survives this, then this person typically has 50 years left. This would be a utilitarian tool. You could begin to ask, okay, not only about the duration, the number of years, but also about the quality of years, which would be very dangerous for disabled people, because there is the kind of stereotype from a perspective of a healthy person that the life of disabled people is completely miserable. Sitting in a wheelchair, not being able to do this, being dependent on, and healthy people in their kind of naive arrogance may say, well, this is no life. Yeah? If I were this stage, I wouldn't want to live. Well, if they are put in the situation, they typically then want to live. This is if the perspective changes. And it's about protecting and this decision, and this is, I think, the valuable point of this decision, which I criticized significantly, I know. But it's actually emphasizing that we can only have this criterion and not subjecting disabled people to this kind of stereotyping from other people, because typically, at least this is this is my impression, the less you have left from your life in terms of time and quality, the more important becomes what you have. And in this sense, this kind of stereotyping shouldn't happen. Okay, thank you.
Muchísimas gracias.
Thank you very much, Professor. We've come to the end of this 3 classes of the cycle. As always, it is a pleasure to listen to you. We learn a lot from you. We learn from this general methodology on how it works in Germany, but I'm also sure that many of us have questions, and we really want to use this knowledge locally. Which type of relevant translations can be made? Thank you very much again. And We will wait for you on March 9 to wrap up this cycle with the presentation of the book Essential Elements of the Dogmatic of Fundamental Rights, that is a compilation of papers by Dr. Borowski. As always, thank you very much to the people who attended via our social media, and also all the workers of the Supreme Court that make these events possible, and that they are also successful events thanks to them. And we will wait for you on March 9. We wish you a very happy evening.
Thank you. Thank you. It was an honor and a pleasure. Thank you.